Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1398 et al. American Federation of Government Employees, AFL-CIO petitioner versus Federal Labor Relations Authority. Mr. Shah for the petitioners, Mr. Peters for the respondents.
Good morning, counsel. Mr. Shah, please proceed when you're ready.
Good morning, and may it please the court. I'm Paresh Shah on behalf of the petitioners. In a one-paragraph analysis, a 2-to-1 majority of the Federal Labor Relations Authority reversed over 33 years of precedent and eliminated the statutory right to union-initiated midterm bargaining. It relied upon the absence of that statutory right to then hold for the first time that a zipper clause proposal is a mandatory subject of bargaining and may thus be bargained to impasse and potentially imposed into a term agreement over the union's objections. For 3 reasons, the authority's threshold ruling on the midterm bargaining right was arbitrary and capricious. First, the authority failed to reasonably explain its departure from its decision in Interior. Second, the authority failed to address important aspects of the statutory question before arriving at its conclusion. And third, the authority failed to reasonably explain its departure from its decision in OPM. If the authority's ruling on the midterm bargaining right is reversed, the zipper clause ruling that explicitly relies upon it must also be set aside. That ruling could not be sustained on the authority's rationale in its decision, which depended upon the absence of the midterm bargaining right. On the first point, the authority failed to reasonably explain its departure from Interior. The authority.
But Mr. Shah, you talk about the failure to explain a departure, but under the Supreme Court's decision in FCC versus Fox, there isn't a special higher bar to explain a change in policy. The policy just has to be explained. There just has to be an awareness that the policy is being changed, which I believe the policy is explicit about that. And the new policy has to be explained. And your brief cited to older precedent that perhaps required more for a change in policy. But I just wonder whether you could speak to whether that line of argument in your briefing survives the Fox recalibration.
Yes, Your Honor. This court held as recently as 2020 that reasoned decision-making requires that when departing from precedent, an agency must offer a reason to distinguish that precedent or explain its apparent rejection of that precedent's approach. And it's the latter that didn't happen here. The singular reason that the authority gave for rejecting the approach in Interior, that single reason simply cannot withstand scrutiny. In Interior, the authority stated that Congress's findings in Section 7101A regarding collective bargaining were as applicable to midterm bargaining as term bargaining, and that nothing in the statute's text supported a contrary conclusion. In the decision below, the authority reframed that observation slightly. It stated that Interior concluded that the statute's text does not distinguish between obligations for term and midterm bargaining, and then it went on to call that view flawed, even though it's a textually accurate view that's shared by the Supreme Court. It then went on to say that the statute's text at 7114A4 clearly established as term bargaining, but not midterm bargaining. But as the Supreme Court stated, that provision and other sections of the statute speak only to collective bargaining without distinguishing between types. And that provision in particular could easily be read in the view of the Supreme Court to encompass midterm bargaining. The authority offered no other reason for its departure from Interior, and it ignored the primary bases of Interior's holding, which were Congress's findings in Section 7101A and the statute's undisputed aims of strengthening unions and equalizing the balance of power at the bargaining table.
If we were to agree with you, Mr. Shah, that the policy statement does not do enough to explain why it takes a different view from the view in Interior, as I read your brief, you think that alone would establish that zipper clauses are permissive rather than mandatory subject of bargaining. Is that your position?
Your Honor, our position is that if the authority's ruling on the midterm bargaining right is set aside, that ruling is the foundation for the authority's subsequent conclusion on the zipper clause issue.
Um,
Depends
But,
upon
but
the-
this, I'm sorry, I think I missed your last phrase there.
Your Honor, I was just saying that the authority's zipper clause ruling, it depends upon its midterm bargaining right ruling, in particular, the absence of that midterm bargaining right.
But the standard for the existence of the midterm bargaining right is, it seems to me as I read our cases, lower than the standard for establishing a permissive bargaining subject. Under the NTEU decision of our court from 2005, we adopted a standard that requires that a right that is going to be a permissive subject of bargaining must be established explicitly or by unambiguous implication in the statute. And that's not a standard that you grappled with in your brief. And I'm just curious what I'm missing. It just seems to me that there are sort of two tiers. One is there a right as a kind of default matter, which is the question that Interior addressed. And then the separate question, which I think I'll acknowledge was not resolved, is the question whether something like a zipper clause is a permissive or mandatory subject of bargaining.
Your Honor, it accurately states the standard and the two different tiers. Our argument here is that, viewing the authority's rationale below, looking only at that rationale, the unilateral rights analysis that the authority performs in, I believe, 1 to 2 sentences, it depends upon the absence of the midterm bargaining right. So if that ruling is set aside and the right is restored, there is no longer a basis for that zipper clause ruling.
And what is that right? That right, if that right is restored, you're saying that right means that you have a unilateral entitlement, which means that it's a permissive subject. Is that right?
Your Honor, we do make that case in the brief that the midterm bargaining right would be a unilateral right. But what's critical here is the court doesn't need to reach that question and undergo that unilateral rights analysis itself. It is sufficient here that the authority in its decision, its rationale for its unilateral rights analysis is on its face deficient.
But you think that it follows that it's a unilateral right as the night follows the day. It sounds, I think that's the logic of your argument. And that may well be right, but it seems like you're tying the two things together so that if there's an overturning, that necessarily reinstates a regime under which, as you understand it, there's a unilateral entitlement on the part of the unions.
What we are arguing is if the midterm bargaining ruling is set aside, the basis for the authority's zipper clause ruling likewise falls. And the result of that would be the previous regime where there was a right that unions had to bargain, to initiate midterm bargaining. That would
a unilateral right.
Correct.
So I have one question about that, which is if you tie, if I can just finish this out, if you tie the zipper clause analysis to the threshold question and the way you're conceiving of it, then in the authority's order that's under review, they also have some explanation about the zipper clause. And that's at page J77. There's a paragraph about the zipper clause issue. And isn't the flip side of your argument then that what the authority says about the zipper clause can also be used as a basis for explaining why there's a departure from Interior? Because it seems to me what you're doing is you're saying, all we look at is this one paragraph with this one textual point, and we just disregard everything else because everything else has to do with some other subject, the zipper clause. But then your own argument is that the two are intimately tied. So why wouldn't the explanation of the zipper clause also feed back into the explanation of why there's been an adjustment from a departure from Interior?
So two things there, Your Honor. I certainly agree there's a relationship between those two rulings and those two issues. But if you look at that paragraph on the zipper clause, that the few sentences of analysis that are there, it simply refers back to the midterm bargaining analysis. It simply says because of its elimination of the midterm bargaining right, neither party would have to waive a statutory right. Therefore, there's not an issue in terms of having a zipper clause proposal be a mandatory subject of bargaining.
Let me just,
I'm sorry.
no, finish up.
Okay, one more, Judge Florida, my apologies. So in that paragraph, though, it's on the zipper clause paragraph, it traces back, but then there's an explanation of why, in the authority's view, that would be a good thing for both parties. There's an explanation of here's how parties would react to that, and here's the sorts of things that parties would do. And I got the sense from that that's the authority's effort to explain why it thought this new regime is the better place to wind up.
You're right. I believe you're referring to the authority's alternate basis for its zipper clause ruling, which deals with the phrase in section 71(14)(a)(4) regarding appropriate techniques for bargaining.
Right. It's the moreover paragraph on JA 77.
That's correct, Your Honor. We view that paragraph as, and I believe this is accurate, an alternate basis for the authority's zipper clause ruling, one that's entirely unreasoned. It's so vague, it's hard to even understand what the upshot is. I don't believe that ties back to the ruling on the midterm bargaining right. It's an independent basis.
And why wouldn't it? Why, if it's an independent basis, even if it's an independent basis, under your conception of it, if the zipper clause issue is intimately tied to the threshold question in your schematic, then why wouldn't that also be a basis for explaining why there's a departure from interior? Is it just that you think standing alone is unreasoned and so we should disregard it at all? Or do you think conceptually it doesn't work to factor that into whether there's been an adequate explanation of the departure?
Both of those things, Your Honor. One, it is entirely unreasoned, as we discussed in our brief. Second, I do not believe this paragraph speaks to interior at all, either explicitly or implicitly. And so for those two reasons, I don't think that this paragraph would help the authority explain its departure from interior. Your Honor.
I just wanted to clarify, you had answered a question from the Chief Judge about the two issues rising and falling together. And I had thought when you were answering a question from me that you acknowledged that there are two separate standards. The standard for establishing the midterm bargaining right that was established in interior is not as demanding as the standard for establishing a unilateral right that would be a permissive subject of bargaining. But that on this record, I thought your point was that on this record, given the way the authority tied the two together, if the authority's questioning of its prior holding in interior were to fall by the wayside, that given the way this opinion is reasoned, the zipper clause holding would also have to fall, but that not that it's sort of more necessarily and generally that the one follows the other. Otherwise, I'm not understanding your acknowledgement that there are two separate standards and that the standard for establishing that a right is unilateral is more demanding.
Your Honor, I'm sorry. The internet connection broke up a bit during your question. Oh. I heard all of it. But if I could just say, our baseline position is that it's one thing to sort of to establish a right, be it the statutory right or the unilateral right that's required for on the zipper clause issue. Our position in this case is that it's the path that the authority took to its destination in each instance. With the midterm bargaining right, the reasoning that it put forth is simply insufficient to explain its departure, nor did it take into account important aspects of the statutory question before arriving at its conclusion. And that is why the midterm bargaining ruling cannot stand. Sorry, please go ahead.
I didn't mean to interrupt you.
And I was just going to add that looking narrowly at the authority's rationale and its decision for its zipper clause ruling, it does depend upon the absence of the midterm bargaining right.
As the authority has framed it. So my follow-up question is just, given the Supreme Court's decision in Local 1309 that the statute is ambiguous with respect to protection of the basic midterm bargaining right, that the authority then, following that decision, recognized, how could it be that the statute unambiguously creates a right making the zipper clause issue permissive?
Your Honor, what I would say there is, while the standard is for the unilateral right is it must be either explicit or vested by unambiguous implication, the limited case law applying that standard, and we're talking about, two DC Circuit cases referencing that standard. I believe only a couple of authority cases applying that standard. In terms of its application, it has not been formalistically applied. Both in our comments, as well as our briefs to this court, we discussed the authority's decision in FDA, which is a decision that this court discussed at length in its 2005 NTU v. FLRA decision. That case, I believe, shows that notwithstanding how that standard is phrased, it has been pragmatically applied by the authority. The authority in its decision below and in its briefs to this court, it ignores that case. But again, I do believe that Your Honors, looking strictly at the rationale below, do not need to get into a unilateral rights analysis in the first instance. It should be.
Right. I have just one other question, which is the dissenting member made a point about reliance, that a lot of existing bargaining agreements were bargained with the assumption that under Interior there is a statutory right to midterm bargaining. And I was a little surprised. I don't see in your brief an argument based on reliance and based on the authority's policy statement failure to take reliance into account. Am I missing something? Are you making an argument that reliance also counsels against the authority's decision to pitch the Interior holding overboard?
Your Honor, I would agree with that conclusion. That's not an argument that we raised below or made in our briefs to this court. But this is certainly a sea change. 33 years of precedent out the window. And without question, that's something that changes the game for unions. It affects their standing in the workplace. Our members depend upon us to be able to bargain over new and unforeseen things that come up during the term of an agreement.
Can I ask just one question? I just want to make crystal clear. It sounds like from your argument, but I don't want to make any assumptions. Is the relevant world here divided into two exclusive categories, permissive rights, I'll call them permissive ones, and unilateral / mandatory bargaining rights. So permissive and unilateral. Is that the world, or is there a third option of something called a statutory right that might provide like a default rule or something if something just doesn't come up in bargaining at all?
Your Honor, it is sort of the two worlds, mandatory and permissive. In terms of statutory rights, that is the larger umbrella under which there are unilateral rights and other statutory rights.
Okay, unless my colleagues have further questions for you, Mr. Shah, we'll give you a little time for rebuttal. Why don't we hear from the authority, Mr. Peters?
Thank you, and may it please the court. I think that the authority, the outcome on the unilateral rights point was more or less dictated, and whether zipper clauses are a mandatory or permissive subject of bargaining was all but dictated by NTU 2005, which emphasizes that the dispositive question is not whether the proposal involves a statutory right, but whether that right is unilateral or not. And it emphasized again 4 different times that a unilateral right must be manifested in the statute either explicitly or by unambiguous implication. The Supreme Court, the second part of that logical structure is the Supreme Court in the NFFE case said that it's not unambiguous. There's no unambiguously manifested right to midterm bargaining in the statute. It reviewed the policy, it reviewed the legislative history, it reviewed the text. It said that it's ambiguous. That's the holding. And then so the conclusion from that has to be under NTU 2005. It has to be that zipper clauses are mandatory subjects of bargaining. And I think that's.
Well, we have to deal with the decision that the authority wrote here. And it's the first part of its decision was that it is necessary. Necessary is the authority's word. Necessary to first address whether there's a statutory right to midterm bargaining under the statute, right? Before it could even get to that zipper clause question. You're kind of making an argument that it sounded to me like we can ignore the first half of the authority opinion and just look at the second half, but they found the one necessary to getting to the other. You agree with that, right? That was the language?
Well, yeah, it was. Well, it was necessary for the authority to analyze the scope of the midterm bargaining right, because NTU 2005 makes it mandatory to analyze midterm bargaining right. To look at that, you have to look at whether the right is established in the statute unambiguously.
Okay, and then the only reason given for that I discern for rejecting the existence of a midterm bargaining right in its I'm going to keep using the same word different in its own right, in its own way, that it exists independently of whether it's negotiated in or out of a contract. So the only basis for rejecting that was the rationale said it's flawed. The authority found that the statute does not distinguish between obligations for midterm and term bargaining. Can you tell me where they said that?
Well, the authority engaged in the unilateral rights analysis on page JA 76 when they noted that the statute presumes that all matters related to conditions of employment are mandatory subjects of bargaining unless the text explicitly or by unambiguous implication vests in a party an unqualified or unilateral right. As explained above, the statute does not.
No. I'm sorry, I wasn't clear in my question. The rationale for jettisoning this many decades of recognizing under the statute a right to midterm bargaining was this sentence, two sentences. The authority's first consideration to support that conclusion is flawed. The authority found that the statute does not distinguish between obligations for midterm and term bargaining. And can you tell me where in that the interior FLRA decision they said the statute does not distinguish between obligations for midterm and term bargaining?
Well, that was the beginning of the discussion in interior, started with the text, and it noted that the text does not distinguish between midterm bargaining and term bargaining. And that was the starting point of the analysis. So for purposes of the zipper clause issue, interiors.
Wait, where does it say that? They cite page 51. I guess I'm not reading them saying that it's unclear as to either. It's unclear as to both. What they say is many of the rationales that lay the groundwork for term bargaining, or what's presumed to be term bargaining in the statutory scheme, are equally applicable, or as applicable as the term to midterm bargaining. But that's not the same thing as saying, I'm just confused as to what this rationale is.
Right.
Statute does not distinguish between obligations. I mean, if what they're saying is the statutory text, I mean, everyone knows going into it, it was ambiguous as to midterm bargaining, at least in the Supreme Court's Chevron sense of that phrase. Everyone knew that going in. No one was disputing that. But they've given a reason here, and I don't see in the opinion them saying the statute doesn't distinguish between midterm and term bargaining, as opposed to, wow, we looked at all the stuff that's in the statute, and many of those rationales that are there seem to apply equally to midterm bargaining. That's a very different proposition than what the authority assigned, unless I'm misunderstanding something.
Right. Well, I think the authority noted that it stated that all matters relating to conditions of employment are mandatory subjects unless the text explicitly or by unambiguous implication.
Sarah, are you talking again about the zipper clause analysis on page 76?
Yes, I see.
Okay, I'm trying to keep you focused on page 75, though. And,
Right.
and they're all they're giving is something that was an error in the FLRA decision, the prior interior FLRA decision.
Yeah, I think that discussion is geared towards determining whether Interior's analysis establishes zipper clauses as a permissive only subject of bargaining based on the argument that that there's an unambiguously stated right or a unilateral right to engage in midterm bargaining.
Wait, so you're saying this paragraph here is all explaining why zipper clauses are a subject of bargaining?
Yes.
But that's not what the authority said. They said we have to do this in two steps. First, we have to address, and I thought you had agreed with me, it was necessary first to address whether there is this right, midterm right to bargaining under the statute.
Right. Well, I think the authority explained in footnote 35 that in the requested issue here, the question of the parties' obligations to negotiate zipper clauses has been squarely raised. And because those obligations depend in some respects on whether the statute itself compels midterm bargaining, we find it necessary to address the midterm bargaining requirements in order to properly evaluate whether zipper clauses are mandatory subjects of bargaining. So we know that this discussion in that paragraph is geared towards the zipper clause holding. And we know that also because the authority said several times, we find that zipper clauses are mandatory subjects of bargaining. We find that all matters related to midterm bargaining obligations are mandatory subjects of bargaining. That was the authority's holding in this case. I don't think that there is any broader holding here other than zipper clause, all matters related to midterm bargaining obligations are mandatory subjects of bargaining, not permissive subjects. Any issues relating to other situations, as the authority noted.
Why would they have to even address the status of midterm, the nature of midterm bargaining under the statute in order to hold that whatever it is, it's not expressed in the statute? Supreme Court already answered that question. Nor is it unambiguously implicated in the statute. Supreme Court already said it's ambiguous. So why did they have to say anything more like attacking and walking away from the interior decision like they do on page 75? Why was that even necessary?
Well, there is
under the theory you're giving.
Right. Well, the reason was because in the comment, NTU's comment, they argued that Interior had established midterm bargaining as a unilateral right. And so the authority is beginning by noting that Interior does not establish that midterm bargaining is a unilateral right explicitly.
Why did they have to say there was something flawed in the Interior decision?
That was the formulation. I mean, it's flawed insofar as it would suggest that zipper clauses are permissive subjects only, right?
Wait, that decision didn't address zipper clauses. I thought everyone agreed that they didn't talk about zipper clauses there. So why is it flawed? They call it flawed for a particular reason that just doesn't seem to bear out.
Right. Well, to
the actual Interior decision.
To the extent that Interior can be read to establish that there's an unambiguous right to midterm bargaining, the statute, it's flawed.
So, Mr. Peters, I'm understanding you in your argument, and also this was my impression from the brief, that the policy statement, to the extent the policy statement purported to overturn Interior, you are no longer defending that.
I think that issues related to whether there's a third position here, whether maybe it's not a unilateral right, but maybe there are circumstances where parties are required to bargain midterm, even absent a reopener clause, absent, et cetera, et cetera. I don't think that this policy statement addresses issues other than whether zipper clauses are mandatory subjects of bargaining.
Oh, no, that's not the way it reads at all. It reads, first, we overturn Interior. Second, on that basis, we hold zipper clauses are mandatory subjects of bargaining. And my question is just to the extent that it reads that way, and maybe you disagree that it does, but if one were to reasonably read it that way, are you now saying, no, we never intended to dislodge interior. All we intended to do was differentiate, because there's a higher standard under NTEU 2005, the question whether zipper clauses are a mandatory or permissive subject of bargaining, and to establish that they're mandatory. That's your position here today?
Yeah, my position is that our position is that, yes, this is geared towards determining whether zipper clauses are mandatory or permissive subjects of bargaining. That was all that was resolved by this.
It's ultimately geared towards that. That's what you ultimately wanted to do, but along the way, it just seems like the whole setup of the analysis is that and as necessary predicate in the way that the authority set up its analysis is to address the question about midterm bargaining, not just about zipper clauses, but about the status of midterm bargaining. Isn't that the entire architecture of the decision?
I think that the architecture of the decision is that the authority looked to midterm bargaining obligations in general in order to determine whether they precluded the holding that zipper clauses are a mandatory subject of bargaining. That was what this analysis was geared towards. I think that as far as other issues relating to, as the authority noted in a footnote, other issues related that this policy statement doesn't address, can address the full scope of midterm bargaining issues that might arise under the statute. And it doesn't address every context. And it notes that an issue arising where there is no reopener clause, the matter isn't covered by an agreement, et cetera, that it would only arise under specific circumstances.
Can I ask this sentence on 75, we find after identifying what they consider a flaw in the interior decision, they say, we find it more appropriate to recognize that the statute neither requires nor prohibits midterm bargaining. Now that sentence, is that sentence replacing the interior holding?
I think that's a statement of where the authority of the general rule that the authority is creating is that this.
Of course it is. Is that statement displacing interior because of interior's flaw?
I think it's again, I don't know that it is displacing interior under all circumstances.
Well, can they coexist?
I think that they can. I think that the duty to bargain questions, which were not addressed in the general broader midterm bargaining, which again, I think this says that it can't discuss every situation under the statute. But I think creating a regime where there is reopeners and zippers are mandatory subjects of bargaining means that parties should settle these issues during term negotiations. There's no reason not to, because they're mandatory subjects of bargaining. So I think that's the rule that this decision is creating. I think under some circumstances.
So do you disagree with Mr. Shah? I asked him this question of whether the world's divided into two buckets or more. Is the world divided into permissive rights and unilateral rights? Or when you say it's not covering everything and somehow the statutory holding interior, although flawed, is somehow still with us, that there's some third bucket of statutory rights?
There may be. We don't. I mean the.
Well, are you reading?
Well, we know that.
Are you reading this decision as? I'm just trying to understand the way you said the more appropriate sentence is not displacing interior was to suggest that there is a third bucket. But I've never seen that before. So I'm trying to understand how you get that out of here or what your basis in authority precedent is.
Well, I mean, the third bucket was not, as you know, it was not raised by the unions in briefs. It wasn't raised in the comments either, but we know there's a third bucket because the covered by doctrine is in the third bucket, right? Covered by doctrine is a statutory right, but it's not a unilateral right. There are lots of grievance procedure, a broad scope grievance procedure might be a statutory right under some circumstances, but it's not a unilateral right.
Covered by is a statutory right as opposed to a way of analyzing whether or not something is eligible for midterm bargaining?
Right. I mean, in certain circumstances, agencies have a right to invoke the covered by doctrine. Official time proposals, for example, there's a statutory right.
Oh, I'm sorry. Okay, I misunderstood what you're talking about. Okay.
Right. There's a statutory right to official time. It's not a unilateral right, meaning that official time proposals are not permissive subjects of bargaining. There's a statutory right to impact and implementation bargaining. Proposals to limit the scope of I&I bargaining are not permissive subjects, or mandatory subjects.
Okay, so to be clear then, so your reading of this paragraph on 75, and I guess there's a line or so on 76, but the section of the decision focused on the prior decision in Interior and the status of midterm bargaining. What you're telling us, what this language means, is that there is still a statutory right to midterm bargaining under Interior. That statutory right still exists, even if
it exists until there's a specific case that comes up that doesn't involve zipper clauses or reopener clauses are covered by. I mean, to give you a sense of how abstract this is, there isn't even a single ULP charge pending before the authority where somebody has raised this as a defense to midterm bargaining, this policy statement saying we don't have any obligation to bargain midterm because of this policy statement. I mean, this is the argument that this policy statement abrogated completely midterm bargaining under all circumstances. That's several steps down the road from this policy statement. This policy statement, as it says in its first paragraph, it holds that zipper clauses are mandatory subject to bargaining.
I just want to make sure in those later cases, you're telling me the authority's position is going to be that, yeah, Interior is still good law as to the existence of the statutory right.
Right. I think parties will have to raise.
No. My question is to you.
Right.
Is it, just to be explicit. Just to make sure we're talking about the same thing, because this is really important to me. In a future case, if someone were to come in and say, well, there's still a statutory right to midterm bargaining, and that was unaffected by this general policy statement, that's still, in fact, this general policy statement still recognizes and preserves that statutory right, the authority will say yes.
Yes, I think that the authority will, yes, I think that this, again, is binding precedent on whether zipper clauses are mandatory or permissive subjects of bargaining. This is not binding precedent on whether there can ever be a right to bargain midterm under any and all circumstances. I think the authority disclaimed that it was speaking, that it was giving a definitive statement on midterm bargaining under all circumstances. I think that's a case-specific inquiry, and there's still precedent out there. The Interior is still out there on that question. This is a zipper clause ruling. It holds that zipper clauses are mandatory subjects of bargaining. That's all that it holds, and it describes the regime that it's creating as one where everything related to midterm bargaining is a mandatory subject of bargaining for term bargaining and should be settled that way. And it gives lots of justifications as to why that regime is good, why it's good to give parties, it enhances collective bargaining, to give parties the ability to control the scope and timing of negotiations over the term of their contract. And that's what this policy statement is geared towards.
Does the authority's decision apply, does this general statement like this apply only prospectively, or does it apply to existing agreements?
Again, I think that it doesn't include anything about I don't think there's anything really here to apply retrospectively, because it's, as I said, holds that zipper clauses are mandatory subjects of negotiation. So if parties out there were already.
Well, no, you've got an existing collective bargaining agreement. Right. And a union comes and says, hey, we need midterm bargaining on COVID. This thing came up, what the COVID policies are, work from home policies or something like that within the agency. We need to talk about those midterm.
Right.
And is it your view that your view that could be forced to the impasses panel now if they started that bargaining and couldn't agree? Or does this only apply to once a new collective bargaining agreement starts?
I think this means that a zipper clause proposal can
No,
be,
no, that's not my question.
right,
My
I
question
think
is about forcing something to the impasses panel.
forcing
A collective bargaining agreement that was negotiated under Interior as a settled law before this decision,
Mhm.
right to midterm bargaining.
Mhm.
There's no zipper clause that's going to solve this problem for us.
Mhm.
An opportunity and necessity for midterm bargaining arises because of
Right,
unforeseen
and there's
circumstances
no,
like the COVID pandemic. And
right,
so they start bargaining and they're unable to agree. And so would that be something that would get pressed to the impasse panel or not?
I think that if there's no reopeners clause, there's no covered by argument, it's very clear that none
It's
of
the
it,
COVID stuff. Of course, there's nothing covered.
right, well, I mean, there are lots of,
My hypothetical is no
Right.
relevant zipper or reopener clause.
right, yeah, I think Interior is still good law until it's specifically overruled in a specific.
So if they aren't able to come to agreement under my hypothetical, would that go to the impasse panel or not?
It could go to the impasses panel.
If they can't come to agreement, would it go to the impasse
Right,
panel?
right, well, I mean, it wouldn't, there's no,
Okay.
but I what you're saying is Interior still good law in the area.
No, what I'm asking is whether this applies to this, if one reads this as changing the landscape, I get that you don't, but if one reads the
Right.
decision as changing the landscape, would that change in the landscape apply to existing collective bargaining agreements or only prospectively?
Reading this not the way that we're reading it.
You're reading it now, yeah.
Okay, definitive. So this is reading this as the last word on midterm bargaining. Are issues related to midterm bargaining now entirely permissive, and any effort to get to the impasses panel draws a ULP? No, I don't think that that's where we end up from this policy statement.
Okay.
Yeah.
Let me make sure my colleagues don't have additional questions for you.
I had one more, but I thought I was
Oh,
talking
yeah.
too much. I was talking.
No, of course.
Go ahead. Go ahead.
Ask your question.
What does appropriate techniques mean? Is there any authority decision defining that phrase? I know they reference it in this decision, but apart from this decision?
I think what this calls to mind about the appropriate techniques is ground rules agreements. So ground rule proposals, which say that allow parties to control the scope and timing of term negotiations. And so those would be appropriate techniques.
I would have thought techniques were sort of the procedures and rules for bargaining, but not actually the content of the bargaining.
Right. Those are rules. Ground rules are rules for bargaining, right?
But not the content of the bargaining.
Right.
Do you have any cite for that for us, just if we wanted to follow up and understand that argument?
So yeah, I that's a really good question. I can give you more on that if you would like, on the techniques language here. But like I said, I think what this is, and this is certainly something that was brought up in the comments, was that ground rules proposals are mandatory subjects of bargaining because they control the scope and timing of negotiations. So what the authority is here saying is that these can be thought of as sort of like a ground rules proposals, but for the term when topics are going to be brought up during the term of the agreement. But yes, I can get you cites on that.
Thank you. That's all I had. Sorry.
Okay. Thank you, Mr. Peters. Mr. Shaw, we'll start with 2 minutes for rebuttal.
Thank you, Your Honor. Just a few quick points. I want to begin with this new view espoused today that the decision below did not depart from Interior, that Interior is compatible with the court's rationale below, the authority's rationale below. That simply cannot be true. Here is what the authority said in this decision below. I'm quoting, "The statute neither requires..."
Where are you quoting from?
Midterm bargaining.
Where are you quoting from?
This is the language that Judge Millett was...
J75.
Yes. And here's what the authority said. The statute neither requires nor prohibits midterm bargaining. Instead, the statute leaves midterm bargaining obligations to the parties to resolve as part of their term negotiations, end quote. In other words, they need to work out what's going to happen midterm at the bargaining table. If a union wants to be able to initiate bargaining midterm, it needs to propose that and secure that right contractually at the bargaining table. That is incompatible with Interior, which said the statute will be interpreted to require agencies to bargain midterm over union-initiated proposals that are not covered by the term agreement, assuming no waiver. Those two things are incompatible. Interior was overturned. And that was the basis of all of our arguments to this court in our briefs. Nowhere in the authorities' briefs to this court did it say, no, wait, hang on, Interior is still good law. This was a new position thrown out today that's simply incompatible with the authority's decision. Second, Your Honors, as I think today's questioning highlighted, the only basis that the authority gave below for saying that Interior was flawed simply doesn't hold up. If you look at page 51 of Interior, which is what the authority cited below for its description of Interior and the subsequent conclusion that its rationale was flawed, if you look at that page, number one, the authority below mischaracterized what Interior said. And second, Interior gave a textually accurate view of the statute. Third, I would add, Your Honors, that as the questioning today showed, the authority did not need to revisit its midterm bargaining precedent to answer the zipper clause question. It simply could have consulted that existing precedent. And as it did so many times over the last several decades, it could have reaffirmed the midterm bargaining right, but then went on to do the unilateral rights analysis that it did without reversing course and departing from that precedent.
And why couldn't we just affirm the zipper clause holding based on the alternative argument on JA 77 regarding this appropriate techniques point that assist in negotiation, to the extent that that's a freestanding rationale that's disentangled from Interior? Why is that inadequate?
Your Honor, I would agree that it's a freestanding rationale. Our argument in our briefs is that it's simply unreasoned. There's nothing, the authority latched onto a single clause in section 71, 14A4 for this vague rationale. Nothing in 7114 or 7119, which is referenced in that section. Nothing speaks to the mandatory versus permissive issue. Neither of the sections support the authority's zipper clause ruling. Unless there are further questions.
I just wanted to get your response to, feeling more confused rather than less now. You said the world's divided into two buckets. Mr. Peters said, no, there's this third bucket. You can have these statutory rights that are neither permissive nor unilateral. They just have their own distinct status. If I understood him right, I hope I got it right, that there's a third bucket. What is your response to that?
Your Honor, when it comes to statutory rights, that's the larger umbrella under which you have rights that are statutory, which are either unilateral rights or other statutory rights. That's the division when it comes to the.
Sorry, I had an internet glitch on my end. So you said there's either, you got your pool of statutory rights and they're either permissive or, and that's where I got my internet wrinkle.
Your Honor, there are either unilateral rights that cannot be the subject of a mandatory bargaining proposal, or there are other statutory rights that could be the subject of a mandatory bargaining proposal.
They're either permissive or unilateral.
Correct.
No, permissive is unilateral. They're either
Permissive or
unilateral,
mandatory.
permissive, or mandatory.
Sorry, yes, permissive or non-unilateral.
We all understood.
Non-unilateral can be mandatory bargain.
That's correct, Your Honor. When there are statutory rights, there are those two buckets. I don't see, and I didn't quite understand the potential third bucket there, but when it comes to statutory rights, they're either.
Are you aware of any authority that has ever talked about a third bucket?
I'm not, Your Honor. And
the authority, I guess.
there's certainly no discussion of a third bucket in the decision below.
Do you think there is a category of statutory rights? It sounds like you're saying it's just that it's on a different axis than permissive versus mandatory, that statutory rights either fall into the permissive bucket or they fall into the mandatory bucket.
Yes, when it comes to rights under the federal sector labor statute, they are either unilateral rights that you don't have to bargain over, they're permissive,
Right.
or they fall into this other category where they could be the subject of a mandatory bargaining proposal.
But the other category is mandatory.
Yes.
Right. Okay. Just to get the terminology right in my mind.
Sorry, I was messing it all up.
No, there's a lot of different words going on in different directions, but okay. Unless there are further questions from my colleagues. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.
Case number 20-5346, Council on Radionuclides and Radiopharmaceuticals, Inc., a Delaware corporation, appellant, versus Xavier Becerra in his official capacity as Secretary of U.S. Department of Health and Human Services and United States Department of Health and Human Services. Mr. Seagroves for the appellant, Ms. Kaiser for the appellate.
Morning, counsel. Mr. Seagroves, please proceed when you're ready.
Good morning, Your Honors. May it please the court. The fundamental question presented in this APA appeal is whether an object of final agency action that requires the object to self-report information to the federal government must quantify the cost of complying with that reporting obligation in order to establish Article 3 standing. We respectfully submit that the answer to that question is no. Now, this court has certainly said that simply because someone is an object of agency action does not automatically create Article 3 standing for the object. This court has made clear that the court must conduct a case and context specific inquiry. Here, of course, the context is the Medicaid drug rebate program, which this court most recently evaluated in Ipsen. At the heart of that program, the engine that drives it, if you will, is the obligation that is statutorily imposed, whereby participating pharmaceutical manufacturers must self-report information for their products that satisfy the threshold statutory definition of covered outpatient drug, which is subsection K2 of the statute. The context at issue here also provides that the failure to timely report required information can, according to CMS, subject the manufacturer to per day civil monetary penalties of $10,000 per day. And it is CMS's view that that penalty provision in the statute, which wasn't specifically addressed in Ipsen, but that particular statutory provision does not have a knowledge element. It is, according to CMS, essentially a strict liability provision.
Can I ask about the declaration, and tell me if I'm mispronouncing, Mr. Stephanos?
That's correct.
I'm just going to call the company AAA to save me a lot of words. Has AAA, not the other company, AAA here, have they filed reports and have they paid any rebates since this rule was promulgated?
The record answers one of those two questions, Your Honor. The record, and this was actually introduced into the record by CMS in its reply brief, which is in the district court, which is docket number 22. The government there on pages 4 and 18 of its reply brief and footnotes on those pages.
Is that an RJA?
It is not, Your Honor.
Thank you.
The
Go ahead,
government,
Liz,
I apologize. The government pointed out there that one of the two products identified in the AAA declaration, namely Lutathera, had been reported following the final rule, data for that product had been reported to CMS. So CMS put that into the record.
But it's your position as a legal matter, presumably, I mean, I'm sorry for my sarcasm, that in order to establish standing, it is immaterial whether any of the members have actually filed reports or paid rebates. And so it's not surprising that that information is not in the JA.
I think that's correct, because I think this court has been careful to say that on numerous occasions that one does not have to demonstrate a past injury in order to establish Article 3 standing in fact. And Judge Millett, just to make sure I answered your question as it relates to the payment of rebates, the record is silent on that issue. And I personally, I do not know the answer to that question.
Doesn't
So,
there,
go ahead.
no, please. Doesn't there have to be some indication that the rule causes some injury? Because if let's just use AAA because they're the only entity that can establish standing now. So the rule had to do something that caused a change to their detriment.
It had to impose or have to impose a legal consequence, or there would be a legal consequence that flows or is caused by the final rule. Here, the final rule's reporting instruction, which is at JA 61, CMS evaluated the threshold question of whether radiopharmaceuticals as a class satisfy subsection K2's definition of covered outpatient drugs. And CMS answered that question in the affirmative, and then said, in language that is quoted in our brief multiple times, said that radiopharmaceuticals are to be reported in the same manner as other covered outpatient drugs.
Right. So, but suppose then that has to have a consequence. And I take it the inference is that it results in reporting obligations that otherwise wouldn't exist.
Yes, Your Honor. And
Yes.
that's go ahead.
And where does the declaration just doesn't say that? And I guess one question I have is, it at least seems conceivable to me that entities who manufacture radiopharmaceuticals were engaging in the reporting obligations anyway. I mean, at least I don't know that that's not true. And if that's the case, then wouldn't we be benefited by some indication that there is an entity that wasn't reporting, but as a consequence of the rule, it will have to report, or it is inclined to report, or something's going to happen as a result of the rule vis-a-vis reporting. It may not be much to do, because maybe that's just the nature of things, but I don't see that predicate part about how this entity is going to change its behavior as a consequence of the rule, from something that it was doing beforehand to something new that will come about after the fact.
Yeah, the record, Your Honor, is silent as to whether prior to the final rule, whether any radiopharmaceutical manufacturer was reporting information. The record does reflect, however, that following the final rule, AAA did report information. I think it's also important to point out that
if AAA was reporting before also, then what's the injury?
From the rule.
The injury there would be if I might want to analogize it to committing an act that's not a crime. I mean, it seems to me that if they were doing it before they're overly conservative and they're concerned about CMS's position that failure to timely report can result in civil monetary penalties and suspension from the program entirely. It seems to me that the fact that they were doing it before, and now CMS has said definitively, put them on notice, that you have a statutory obligation to report. The fact that they did it as a conservative matter prior to the final rule doesn't mean that the final rule hasn't changed the legal consequences of them failing to report.
I mean, it's always, as is often the case with standing, it's hard to disentangle the merits and the standing. But as I take it, CMS's position is that under the statute, as under the rule, if a state scheme bundles the administration of a prescription drug with a hospital service and bundles the charging for it, that's within the limitation of the definition of a covered outpatient drug. Whereas if the state, and this is going to vary from state to state, if the state bundles the service but separates out the charge, that you do have to file and participate in a rebate program, and that seems to, so to the extent that that there's some new unclarity that the rule mean, I understand that the industry wanted more and didn't get it in terms of a categorical thing, like you guys are not subject to this, but I'm having trouble seeing what your theory is of how the rule created a kind of a trap for the unwary, and that you have members who can show that their conduct and or, you know, concretely described risk shifted.
Certainly, Your Honor. So the discussion in the final rule that immediately follows the discussion of radiopharmaceuticals goes into some detail as it relates to how does the statutory limiting definition, subsection K3, how does that affect essentially a participating manufacturer's obligation at the threshold to report information? And essentially, CMS takes the position that whether or not the state of California, for example, pays for your thing separately or not, that only affects rebate liability. That does not affect the threshold obligation to report information. Because if we keep in mind the chain of events here in the statutory scheme is that the manufacturers self-report information to CMS. CMS then provides that information to the states. And on page 62 of the joint appendix, the final rule makes clear that CMS relies upon the states to then use the information that has been self-reported by manufacturers to determine whether a rebate is owed, because the states are responsible for invoicing the manufacturers for the rebate.
Can I go back to this? You mentioned the government's acknowledgement that, at least as to Lutathera, AAA has been filing reports since the rule was adopted. Do we know whether those same reports were filed before the rule was adopted?
We do not. The government in the district court provided a link to a CMS website that had the data. When one pulls up that link currently, one sees that, I should say this. Lutathera was not approved by the FDA until after the final rule was. Okay. I apologize. Light bulb, I apologize.
Then it doesn't help that much anyway, because then we don't know the ex ante. We don't know that anything changed as a consequence of the rule. Just because reports are filed after doesn't mean they weren't filed before. I think, unless I'm missing something.
Was AAA? Go ahead.
So the report, the report to which, or the database that CMS linked to in the district court, demonstrates that Lutathera, the first reports filed by Lutathera were not filed in 2018, which is 2 years after the final rule issue here. And that makes sense because Lutathera was not approved by the FDA until 2018.
But AAA has other drugs. I don't know how far back this database goes, but does it show, or can you tell us whether Lutathera filed anything before as to a radionuclide?
They did not. For example, the other product that is specifically identified in the declaration, the database, CMS's database, reflects that no reports were filed for that.
For that one, it doesn't reflect that any reports were filed after either, or does it?
Correct. It lacks any information in it for any such reporting, which would indicate that no such.
I guess the bottom line question for me, I think for my colleagues as well, is there anything in the record that shows that there was some radiopharmaceutical as to which reports were not filed before the rule, but are filed after the rule?
No, there's nothing to that point in the record. We go back to.
Is there anything on this website, like the judicial notice thing?
The website itself does not, the database, CMS database does not indicate whether a particular product is a radiopharmaceutical or not. It lists NDC codes and the like. So I don't think that one can look at that database and reach an assessment of whether conduct necessarily changed pre and post rule.
But your association members should be able to answer this in about 5 minutes, right?
I would say so, Your Honor. I'd also say that, again, if we keep in mind that this is a statutory scheme where CMS takes the position that essentially there's strict liability for failure to report.
You have to marry that with their explicit representation in the rule that, look, we realize that this reporting stuff is confusing. or more complicated maybe for radionuclides. And I don't know if I'm saying that right either, but we're here to work with you. That makes it a little bit harder to find a risk of prosecution. Are you aware of any radionuclide manufacturers that have been fined? Have any of your members been fined since this rule was adopted for not properly reporting?
No, for example, in Ipsen, after oral argument, the government submitted a letter that listed past instances in which the failure to report CMP provision had been implemented. And my understanding is that none of those examples involved radiopharmaceuticals.
So, Mr. Seagrove, I'm a little confused about your characterization of the scheme as imposing strict liability. I had thought that that at least your member's declaration said that manufacturers must make good faith, reasonable assumptions, and if they're doing that,
well, first of all,
I think that CMS is going to interpret its assumptions. It's a bungled good faith effort as amounting to a knowing false report. Or I guess I had two questions, just to be clearer. Where in the statute are you looking to find the strict liability?
Sure.
Is that the late filing provision, or?
Yeah, and if I could clarify at the beginning, that CMS's position that there's no knowledge element, and this is subsection B3C Romanet 1.
Can
and
you
that's
tell me in the
the addendum to the blue brief at page 6, right-hand column.
addendum to the blue? Oh, it would help to have the brief from the right case. You.
The heading is failure to provide timely information.
So timely, so there's maybe a strict liability for lateness, but your argument is not that the new rule makes it imminent that AAA will be late with its filings.
No, but we rely upon both of the penalty provisions, both that provision and the false information provision. So when we say the declaration says that one has to make reasonable good faith assumptions, well, first of all, that's a factually unrefuted statement in the record. But it's, I think that when we were talking about that aspect of the declaration, we're talking about the round peg square hole problem with the Medicaid drug rebate program being set up and administered in such a way that, for example, to report the current reporting structure as such, and the reporting structure was such at the time, that the dosage data of millicuries, for example, which is an important term in the radiopharmaceutical context, was not an option. And CMS,
I'm just dialing back to your assertion that there's strict liability. I just don't see it. I think in the very column that you pointed to, which is what I had read, any manufacturer with agreement under this section that knowingly provides false information. So if you, and then there's an obligation to timely provide information. If you do your best, provide some information, turns out it's not what CMS wants, you're not going to be liable, right? You have to timely file something, and CMS says we stand ready to help, and then the knowingly is only when the information is false. They've tried to guide your members, and your members have nonetheless obtusely, given the wrong information. And that's not what they're claiming is their problem, is it?
Well, again, if we look at the CMP provision for failure to report, it has no knowledge element. CMS represented this court in Ipsen that there is no knowledge element. You violate that. If you factually violate that, you're at risk for CMPs. I'd also, to put in context CMS's statement in the final rule that CMS remains willing to work with radiopharmaceutical manufacturers, the administrative record in this case reflects dating back to at least as early as 2010, which is actually prior to the proposed rule. The council was working with CMS in trying to deal with this issue and get the clarity that it needed. So that's at least a 6-year process. So for the agency to say, in the final rule, we will continue to work with you. I think one has to look at the record and see, well, what has been the course of dealing thus far? And we're talking about a 6-year process that has.
Is there a course of such dealing prior to the promulgation of the proposed rule? Were radionuclide manufacturers already, many of them assuming under the statutory language that they had to file these reports, already doing so? So this confusion even pre-existed the proposed rule?
That's not in the record, Your Honor.
But it's not in the record either. I mean, we don't know that that wasn't the case.
True.
Or we don't have any reason to think that AAA thought that the state of the world beforehand was in one direction or the other, with respect to the particular point the Judge Millett raises.
That's correct. Because again, look, we're talking about a 6-year-long process of engagement between the council and the agency.
So I'm just sorry, this is my mistake. Is that 6 years the time period between the proposed rule and the final rule?
No, Your Honor. So the record, the proposed rule is 2012. The final rule is 2016. So 4 years. The engagement between the council and CMS, and this is reflected in the administrative record, and this is in the JA, just to be clear. And then, for example, if one goes back to, if you indulge me, I realize I'm over my time, but there's a letter from CMS to council for the council. That's a poorly way to put it, but there's a letter in the record where, and again, this is prior to even the proposed rule. If you indulge me, or if I maybe I'll bring it up in a rebuttal if that.
That'd be great.
That's fine.
You say but to the rest of your recollection, there's a letter even prior to the proposed rule that talked about this topic?
Yes, Your Honor, and it's JA 121, and it says, quote, consequently, we, and this is CMS, believe that radiopharmaceutical manufacturers need to submit the necessary baseline data and pricing information to CMS.
That was even prior to the proposed rule.
Yes, Your Honor.
All right, if my colleagues don't have additional questions for you at this time, we'll hear from the government. Thank you, Mr. Seagroves. Ms. Kaiser.
Good morning, Your Honors, and may it please the court. Bridget Kaiser for Secretary Becerra in the United States Department of Health and Human Services.
A little bit of I'm sorry, I'm getting a little bit of an echo from your audio. Is
this a little better?
It's a little better when you're leaning closely. Yes, thanks.
Okay, I apologize, Your Honors. As we've discussed, the council's associational standing depends entirely on AAA's, and the district court twice looked at that declaration and found it wanting in establishing standing.
Is that exactly right? The Bragg declaration says, I've never been in this Medicaid program, never needed to before. And if I have to come into it, it's going to take a ton of paperwork from me that costs money, right? It makes the economic analysis and complaint there about what it'll take if it has to come into the Medicaid program. Isn't that relevant to show that this rule causes a manufacturer of these pharmaceuticals that's a member of this association to have to make this economic choice between taking on this economic burden or not being reimbursed under Medicaid?
Well, the Bragg declaration, which the council doesn't rely on here, didn't actually say, as I recall, that manufacturer wanted to participate in the program or didn't want to participate in the program. I think that's what Judge Walton concluded about it.
Right. But it certainly makes clear that these reporting requirements impose an economic cost, right? We have that fact in the record. I mean, it's pretty self-evident, but these reporting requirements impose an economic cost. The government doesn't dispute that these reporting requirements impose an economic/resource cost on participating companies, does it?
On manufacturers generally, what I would say,
anybody who has to do, I don't mean generally, just is there any way anyone can comply with these reporting requirements without expending costs, resources?
I wouldn't say that, but what I'd say is that
I'm sorry, you wouldn't say what? it was a question that I was asking you. Is there, is there any way to comply, yes or no, with these reporting obligations that is cost-free and resource-free?
No, I don't think you can cost-free comply with reporting requirements, but I would point out that the declaration submitted by AAA doesn't appear to complain about the cost of complying with reporting requirements. What this declaration focuses on instead
jurisdiction is we have an obligation to satisfy ourselves with jurisdiction. I think that runs both ways. If it's crystal clear on the record and you have just admitted that this new rule imposes a regulatory obligation, and that regulatory obligation causes an injury, costs resources, just does, clear as day. Why doesn't that mean they're standing? We have jurisdiction. We have a duty to exercise what jurisdiction we have.
Well, I think the plaintiff has the burden of establishing that it's injured by this rule. And as has been observed, we don't know whether the rule caused it to report or not.
We do know that the rule, that it has been reporting under this rule.
It's been reporting under the rule which parrots the statute.
Now, let's be fair. Your rule itself said you're clarifying this.
Yes.
Okay, then. So under the rule, they're complying with these reporting obligations, and it was really hard. It's really hard to use for him, is what they're for this company.
If I could take one step back for a moment, what the rule says is not that every radiopharmaceutical is a covered outpatient drug. It says that some of them are when the limiting condition doesn't apply, the limiting provision. And as has been discussed, under the limiting provision, if a state pays on a bundled basis for radiopharmaceuticals, then they won't be covered outpatient drugs. The council itself has said that virtually all the time, its drugs do fall and are paid for on a bundled basis.
But they don't know at an upfront basis, right? The reporting obligation kicks in long before some state seeks a rebate. And I take it these companies, they don't have any control over how somewhere down the line their drug is billed or not by third parties. So the reporting obligation exists, I should think, across the board. They've got to do it if they want to get paid under Medicaid, or they want to get paid even if it happens, its drug is used in a Medicaid to treat a Medicaid recipient, right? They can't know up front at the time the reports are due how their drug is going to be billed, can they?
Well, I suppose they could do some investigation to find out if any state is billing separately for their drugs. As I understand,
that wouldn't, even if they hadn't in the past, that wouldn't stop them from doing it going forward. They can't. This is something they can't. They can neither control nor know at the time of the reporting obligation, right? Particularly the way these drugs are used, right?
I agree. It is a situation.
The limiting provision does not alleviate folks of a reporting obligation.
Or does it? I mean, that's a question for you as the administering agency. If today not a single state separately bills for radiopharmaceuticals administered as part of a bundled service, does the industry still have to file because it's a possibility that a state might decide to break that out later? What's the government's position on that?
There's no reporting obligation unless you choose to enter the program.
Once you're in the program, like AAA says, we chose. Why isn't it enough that they said we're in the program? We have a Medicaid drug rebate program agreement with CMS. Why isn't that enough to make clear that whatever beef it has, meritorious or not, with the rule is one that it has standing to raise? What more would you want as a standing matter than, hey, I'm in the program?
Well, the two injuries that I identified coming from the final rule were rebate liability, which is not mentioned in the declaration. Rebate liability would only flow if the limiting provision didn't apply to either of these drugs. And the other one being enforcement actions, which has already been discussed, are unlikely in a situation where we've invited manufacturers to come discuss with us any reasonable assumptions they might want to make. So
can't we at some point just use undisputed sort of common sense under the regulation that says, you radionuclide manufacturers, I'm looking at you and I'm pointing at you. You are now covered. If you had any questions before, we have exercised our authority and we are making crystal clear, you are now regulated. If you want to be part of this payment program, you're in it. And as you just said, the statute requires you, now that we've pointed to you and said you're covered,
right,
file reports. I'll say constantly, it's on a quarterly basis, but that's just an ongoing duty to file reports that are at least complicated in this area. And as you have admitted, will require resources and to pay
only if rebates are due.
Are you aware, is Judge Pillard's predicate accurate? Is there no state in this country that bills separately for radionuclide medicines, pharmaceuticals?
No, it varies by drug.
Okay, it varies. So exactly. Right. So they can't know going in. So they all have to report, and some percentage of them are going to have to pay rebates, and they may not know coming in whether they're going to have to or not. Can you tell us that AAA has never had to pay a rebate? Do we know that?
I don't know, but it was AAA's burden to identify whether it did, I think. I don't think that the district court had an obligation to guess at that or to guess.
No, but there's no guessing required for reporting obligations. And there's no guessing for whether those reporting obligations impose a cost, resource cost on AAA. There's no guessing as to that. I mean, we've said before, sort of economics 101, we don't need to be led by the nose to everything.
Right. I would say this. As I mentioned, that the declaration appears directed entirely at wanting more guidance.
Okay, so if they put that one sentence in that you as the government have already admitted is universally true. Reports required by AAA and reports are going to take your resources. They're going to have to expend resources to do them. If they add that sentence that is self-evidently true, then there is standing?
If what they want is not to report.
If they say that as a result of this rule that pointed to us by name and said, right, you're now covered, I have to file reports, and that takes resources. As a result of that rule, they would have standing, yes?
That would show an injury, but I don't know that it would show standing. Because
just on the injury question, that's all. I guess you have separate argument on that. It would show injury,
unrelated to the rule, or
I mean, I think they would have to say that they report because of the final rule, rather than because of the statute.
So if it's a particular entity, let's take away from the association just for now. I know that this is an association, but if it's a particular entity and they file a declaration that says, beforehand, we weren't filing reports because we thought our radiopharmaceuticals didn't constitute CODs. But now you've told us that they do, and so we're going to have to file reports afterwards. We're injured. That just seems like a straightforward case of injury. There's no doubt that the injury requirement is satisfied in that situation. I take it.
Yes. Although, as alluded to earlier, the council was aware that CMS took this position even before the final rule.
But if their allegation is we weren't doing it before. Now that you've put it in the comment, we feel like we have no choice. Therefore, we're engaging in reporting that we weren't engaging before. It's hard to see how that doesn't satisfy the injury requirement.
Certainly, if the declaration said all of that.
Right. And so, and it's absolutely clear that there are reporting obligations that must be met by manufacturers of radiopharmaceuticals. Now, of course, I know that there's this subsequent question about whether they get out because of the limiting principle, but just put that to the side because we're only talking about reporting obligations at the front end. It's absolutely clear, and there's no dispute, and it's hard to see how there could possibly be disputed, that as a consequence of being part of the program and having a drug that qualifies as a COD, reporting obligations are owed. So then it seems to me the only question is, were they reporting beforehand anyway? And as to a particular entity, maybe there's a question whether they were reporting beforehand anyway. I think one of the questions is, if we're dealing with an association that covers the entire industry, is it not fair to just assume that at least some people are now facing reporting obligations that they otherwise wouldn't have faced? And that's just so obvious from everything we know about this regime that the injury requirement is satisfied.
Well, a couple of things. I would say, first, given the nature of this declaration, it's not at all obvious that they don't want to participate in the program, which after all comes with the benefit of mandatory Medicaid coverage of your covered outpatient drugs. So it's not, without knowing what the precise injury of the identified association member is, we can't know whether the relief sought redresses that injury or whether the final rule caused it. Secondly, I would say this court has recognized that it's in Swanson Group that the question is not whether they could have standing to bring the claims at issue, but whether the evidence the plaintiffs presented in support of standing is sufficient. And in American Chemistry Council, this court said our standard has never been that it's likely that at least one member has standing. I think they have an obligation to come forward with one association member who has an injury that's clearly caused by the final rule and redressable by the relief that council
Well,
seeks.
I want to follow up on this, what the rule changed universe, because I'm very confused. You all were telling before the rule, they were supposed to report. Were radionuclides getting reimbursed or getting paid somehow under the Medicaid program even before this rule? I don't know what all the different mechanisms were. Okay. And even if they were reporting something then, maybe they were reporting in the way that they tell us in the brief, they package information. They don't, the reporting, what they want to say is sort of, it's a rather Procrustean effort to try to take the information that we have about our pharmaceuticals and fit it into the way you want covered outpatient drug reporting under the scheme and under the final rule. So even if they were reporting something before and getting and participating in Medicaid or receiving Medicaid reimbursements before by reporting information in the form in which they have it before, if the consequence of this rule is that you now have to report just like other covered outpatient drugs. And so you're going to have to apply costs and resources to report in a way you haven't reported before, and that CMS acknowledges is a difficult fit for your particular type of drug, then that type of additional reporting burden would be an injury, correct?
I think that could be articulated, yes, as an injury.
That would be an injury.
Yes.
I've articulated.
Yes.
If
Yes.
I've articulated, that would be an injury.
Yes.
Is that the reality here? Because no one tells me what's going on beforehand. Right? I'm very confused as to, it seems like they were getting paid somehow. And it seems like Medicaid was already dealing with them for some way. And most of this is like, this new obligation doesn't fit what we do and even who we are. That's one of their merits arguments. Is that the delta we're talking about? Is that now to keep getting paid by, it's not that they want to participate in Medicaid, as you said previously, they were already getting paid, and they're not going to lose that money unless they spend extra time and resources to figure out how to report in a way that they've never reported before and that doesn't fit, in their view, the nature of their product. Is that what's going on here?
Well, most of the time before, as I understand it, radiopharmaceuticals have been and continue to be bundled. Most providers bill states on a bundled basis. And so it hasn't been, and when that happens, Medicaid.
Most, but was it universal?
When that,
I'm sorry?
You say most were doing it on a bundled basis, but was it universal? Were states universally paying them only on a bundled basis? And something on the state end has changed?
I'm not aware of any earlier. I'm not aware of all the history of whether any state has ever billed separately. I only know that it's most of the time they've been bundled. I think there may be renewed interest by states in approaching CMS about how they can bill separately because of
they get more money that way.
Because of the option for rebates. But most of the time, radiopharmaceuticals are billed on a bundled basis.
I guess if it just seems it's clear from the nature of the statutory scheme that you can't do it without expending resources, extra resources under this rule, because you all don't dispute that this is a more complicated. They can't. It's not as easy to figure out how to fill out the reports for them as it is for, maybe a pill manufacturer. Then what? Why isn't it just evident from this scheme that Mr. Stefanos, who's struggling here, he and his company are struggling here to figure out how to do this, are expending resources in the process? He had to take his time to do the declaration, for goodness sake. I know that can't create the standing, but I'm just saying, they're struggling. They're struggling here. That would be too easy. They're struggling. They're struggling with it here, and struggling means resources. We're going to have to meet with CMS.
Right. I'm not sure of the.
I'm wondering what the end game is here. Really, if we all know there's an injury, they just need to add a line. He's told us we don't know how to do it. You're saying come meet with us. That requires resources, right?
But it's not something
that requires resources,
yes,
right?
Yes, okay. Yes, Your Honor, it does.
Don't dispute their good faith representation that we can't figure out how to do this because it's round peg, square hole as far as we're concerned, right?
That's right.
Okay, that's resources. We all know there's resources being expended. Why are we're going to go back and make them start all over again? This just seems like code pleading. Formalism for the sake of formalism. If we all know, we have to be sure standing exists, to be clear. If we all know it does.
Well, I think what we've been focused on just now was injury. I don't think it will be possible to answer the redressability and causation questions without knowing exactly what injury the identified member.
The injuries, we have to fill out these reports the way the rule requires them. That's their injury. And it'll be redressed if they win. They may not, to be clear, but we have to assume on the merits at this stage they're going to win, and they're going to obtain a ruling that they are not covered outpatient drugs subject to this reporting requirement. That seems like pretty clear causation and redress to me.
Except that their declaration doesn't complain about the cost of reporting. It complains about a lack of guidance. So
which requires them to do what? Under your argument, come work with us.
Well, or make reasonable assumptions.
Mm-hmm. And that either one takes resources. Does it not? Make reasonable assumptions where? In your reports to us. And you stipulated that there, you said, we're not doing fact stipulations here, but you said that requires resources 100% of the time. And working with you requires resources 100% of the time.
But
it's like one of those cases where we said this is just obvious basic knowledge on the statutory scheme, that if you're in it and you don't think you should be in it, you have the injury because the scheme requires us.
Except this manufacturer doesn't say that it doesn't want to be in it. It doesn't say that it's had to pay rebates in it. It says only that it would like more guidance.
This manufacturer is in a litigation that says we should not be in this.
Well, that's what the council says.
No. They are a member. This association is litigating on their behalf. I think we can make that leap. That they share the views of the litigation that they are supporting through their declaration. That is, they don't think they should be covered. Really, people have to in their declaration. We're going to kick them out on standing grounds. We can't see how we have a jurisdiction because we're not sure that this declaration by sort of a client member of the association agrees with the litigation. That's what our theory is now.
I think they should at least articulate that they have had to pay a rebate or that either one of their drugs has been swept into the definition of covered outpatient drugs when it ought not to have been.
So here's a question. Is the fact that a company is entered into the Medicaid drug rebate program and has an agreement with CMS for these drugs, doesn't that imply that there's a state that separately charges for these? Because that's an essential triggering condition for both reporting and rebates, right?
No, a manufacturer could enter into a drug rebate program sort of on a prophylactic basis if it wanted to. It could report information and never owe rebates.
So on a prophylactic basis, it's just thinking if any state decides to do this, we want to be ready to recoup. We want to be able to get to participate, and we recognize that we'll have to pay rebates then, but it's not now up and running in that way. And so that's what you're looking for is the company to say not only do they have an agreement, but that there is some circumstance in which they're obligated to pay rebates. And nobody knows that. Nobody's in this record that hasn't been made clear. And it's your view that that's the plaintiff's burden.
Yes. As I understood, opposing counsel said he's not sure whether this manufacturer does have rebates. In the briefs, they said they flow automatically, but that's just not the case.
So well, they only flow automatically if there's this. I thought you had said you didn't know whether any states separately charge. And isn't that a precondition for rebates? Bundled service, but separate billing line for the radionuclide.
Right.
And if there's no separate billing line, then there's no rebate obligation on the COD manufacturer.
Correct.
I thought you said some states were separately billing.
I don't know whether any state is separately billing for either of these.
But they're separately billing for radionuclides.
There are some radiopharmaceuticals that do pay rebates, yes.
And when you say filing on it or entering into an agreement as on a prophylactic basis, I heard Mr. Seagrove to say, there's this, and it was a focus of some of Judge Millett's questions, but I didn't have a clear takeaway. If I haven't entered into an agreement and it turns out later that my radionuclide, the situation changes on the ground and the state starts billing it as a separate line item, I'm not exposed to liability all of a sudden, am I?
No, if you're not participating, the consequence there will be there won't be federal financial participation paid to the state.
So unless and until the state won't be paid for it. So the state presumably would have an interest in telling me, the manufacturer, hey, we're going to separate this out as a line item. It'll be good for us, might be good for you. Yeah, you'll have to pay rebates, but that's coming. Why don't you file, get an agreement, and we're going to go from here.
That's right. There's no penalties if you don't participate in the program. The incentive will be if the situation changes on the ground and then the state doesn't want to buy your drug.
But do this, I just don't know how these things work, because it sounds like some of their things go to these specialized pharmacies. And then those pharmacies, I guess, provide them to the hospitals or the doctors' offices. And if you can't answer, maybe Mr. Seagroves can, do they get paid up front? Do the manufacturers get paid up front? You know, someone's ordered this thing, we send it up to the pharmacy, we're getting paid now. To whom it ends up going into, we have no idea.
I'm going to defer to opposing counsel and how his clients get paid. I'm sorry.
Thanks.
Seems like the kind of thing that might have been helpful to have laid out in a declaration to answer some of these ambiguities, but let me ask my colleagues if they have additional questions for you, Ms. Kaiser, and make sure that we don't. Okay. Thank you, Ms. Kaiser. Mr. Seagroves, we'll hear from you for rebuttal. Why don't we'll give you 2 minutes and we'll see where it goes.
Thank you, Your Honor. So to answer or to provide the court with a record citation where it can go into this question of how the mechanics work. In fact, it is true that, and this is reflected in the background paper at JA 113, that a radiopharmaceutical manufacturer sells its product to a radio pharmacy and gets paid by that customer. It does not bill the state Medicaid program directly. Instead, typically that's whatever service provider provides the end service using the radiopharmaceutical. I think one of the things that we've seen here this morning is, and why we're, I think, wrestling quite a bit with causation.
So why participate in Medicaid at all?
It is a condition. Yeah.
Because you're getting paid by the pharmacy. I don't know that the pharmacy knows whether the ultimate recipient is going to be a Medicaid recipient or Medicare or private insurance.
It's a condition for if you want to have any of your products covered by Medicaid, and not just radiopharmaceuticals, but any, you have to participate in this program. And I would say that, we talked quite a bit.
I thought AAA here only did radionuclide medications.
The record doesn't say that that's what they only do. It identifies 2 radiopharmaceuticals that it manufactured. Doesn't speak to its portfolio beyond that. The government.
So when it says we manufacture and distribute pharmaceutical products, it doesn't mean exclusively. Okay.
Correct.
But that also doesn't that enhance the ambiguity of the declaration? Because one question I had in reading it at the outset was, they say we have entered into a Medicaid drug rebate program agreement. And I asked, for these drugs? So the fact that it may be registered and have an agreement with Medicaid actually doesn't tell us anything about whether that relates to the issue in this case, does it?
Well, I think it does, because it shows that it's subject to the reporting obligation, the potential rebate liability, and the potential penalties for failing to comply with CMS's reporting instructions. The government.
Yeah, of its drugs. Is that what you mean? Because once it registers, it's registered for all of its drugs.
Correct. The rebate agreement is not product specific. It's essentially everything. I think it's important to point out that the government didn't raise causation in the district court. Now, certainly the government can raise it for the first time on appeal, but when we look at this factual record and we try to understand what Mr. Seagroves and his colleagues were thinking in the district court with this record, the government didn't raise standing for the first time until we sought summary judgment. And in doing so, the government's chief complaint was that we hadn't identified a single member. We rectified that problem. The government never made a causation argument or redressability argument. They raised that for the first time on appeal. I think that while the government's free to raise that argument on appeal, the degree of lenity that one should answer that question with the record that was created below, one has to recognize what were the arguments made below, and therefore what evidence was put into the record as a result. Just one last thing, to Judge Millett's point about, I think, referring to the Curiam Declaration, I would just point this court to its decision in Fund for Animals, which is cited in our reply brief, where there the court did not have a affidavit from the putative intervener at issue in that case, who was found not to have standing. And this court nonetheless looked to the allegations made in another putative intervener's declaration. And in fact, the arguments made in the opponent's pleadings in that case. So for those reasons, it's been a very long argument session.
Can I ask one quick question? Oh, go ahead. Sorry.
Oh, no, go ahead. I have one question, please, Judge Millett.
I'm just trying to understand something. So there's a Medicaid state utilization data table for 2021 that shows states have paid for Net Spot and Lutathera. So would that indicate that they were billed separately then? I don't know how else they would pay for them directly.
Yes.
So there's no question then that at least some states
That's right.
are
That's right.
billing separately for your AAA's drugs, and that's
Correct.
a matter of public record.
Correct.
Okay, sorry.
And I just have one clarificational question. We spent a lot of time this morning talking about the potential burden in terms of reporting obligation that's imposed on manufacturers who become part of the program and then are told that your drugs are actually, they qualify as CODs. Just want to make sure that that's right, that is an injury that you in fact feel is happening and is undergirding your action.
Yes. I think it's one of the reasons why, quite frankly, the council has been engaged in negotiations with CMS for now, if you can include this litigation, for over a decade. The notion that the AAA declaration doesn't expressly say that we don't want to report this information, I think, as Judge Millett points out, I mean, it's filing that declaration in the context of litigation brought by its trade association that's saying CMS made a statutory error and that this stuff doesn't even satisfy the threshold definition of a covered outpatient drug.
Right, but I think the question is, and therefore X, and the therefore could be any number of things because there's more than one type of injury that's being bandied about in this case. But
True.
One of the easiest ones to get one's mind around is maybe the most straightforward one that comes about, which is that this imposes, if not, and I'm not necessarily suggesting that it's reporting in the and in the ex ante regime, there wasn't any reporting at all, but it's that there is a different kind of reporting obligation, which I'll just call a new reporting obligation. That wasn't evidence before.
There is a reporting obligation that is a direct product of final agency action.
And
It wasn't present before under the statute.
Correct. I think that while the 2000 letter I mentioned from CMS, which predates the proposed rule, whether that under Ibsen, for example, whether that could be characterized as final agency action, I think is subject to some question. But there's no question after notice and comment, and the government's never made a final agency action argument in this case, that the final rule definitively resolves that issue.
CMS acknowledged that there had been ambiguity and confusion about this.
Well, they acknowledge
it was creating clarity.
Correct. The final rule, and this is J61, specifically notes that it received a comment, and the government's brief in this court acknowledges that that comment letter was from the council. And in fact, the preamble discussion of this issue, as it paraphrases a large paragraph from the council's comment letter. So I think the cause and effect, if I may, there is pretty clear.
And the new reporting obligation imposes, compliance requires an expenditure of resources that would not have been required beyond what was required before to engage in whatever reporting was done before.
Well, the reporting obligation is the same, but the consequences for violating it, I think, are markedly different given the statutory penalty scheme. I think it's also.
Wait. So you're saying
that's. Go ahead. I'm sorry.
Okay, I think we're asking the same thing. So did you just say that whatever reporting they were doing prior to this rule is no different from the reporting they are doing after the rule? It's just that now we're sweating bullets about trying to fit our information into this particular format, because if we got it wrong, oh well. But now if we get it wrong, we're doing the same thing, but now if we get it wrong, we feel like we're at risk of penalties.
That's exactly right. The framework, if you will, the template for submitting this information didn't markedly change for these purposes because of the final rule. It's the same. It's like, think about it. It's like the same form. The form didn't change. Forms perhaps
Just
a bad word.
they're worried about consequences.
Correct.
Oh, then I think
Okay.
I was confused about that. So there is no new reporting obligation. It's just that the consequence for not doing the reporting obligation that stayed constant throughout has changed.
Well, I would say that there is a new reporting obligation because CMS has said definitively you have an obligation to report, whereas they hadn't said that definitively prior to the final rule.
But I thought you just said that actually the same reports that were being filed before are being filed now. It's just that the consequence has changed.
Well, the record, so I should clarify, the record is silent as to the change in what, if any, change in the forms there were. The only thing in the record.
But you just told us it's the same form.
Yeah, I mean, the information, and this is discussed in JA 62 when it's talking about, and elsewhere in the final rule, talking about the mechanics of reporting this information. You know, whether something was a covered outpatient drug or not, for example, the category that one used wasn't, you know, I think greatly changed as a result of the 2016 final rule that's at issue here. The consequences of not filing certainly did change.
I see. So the what was considered a covered outpatient drug didn't really change as a consequence of the rule.
Well, CMS, I think, would probably take that position in light of the 2011 letter. I don't think
you all were operating under the assumption too.
No, I think that we still viewed it as an open disagreement with the agency on this issue, which is why we sought clarification during the notice and comment process.
All right. Unless my colleagues have further questions for you, Mr. Seagroves.
Thank you.
Thank you to you. Thank you, Ms. Kaiser. We'll take this case under submission.
Thank you.
This honorable court is now adjourned until Friday, October 15th at 9:30 a.m.